Okay, next case on the docket is Creative Environmental Solutions versus CROOM Investment.
Are you going to explain the striking of the...
Did you vote? Did you vote? I don't know, before we start, I don't know if the parties got this order, probably not, unless you get emails to your phone. The order may not have been entered, but we did vote to grant the motion to strike that second notice of supplemental authority. So,
Thank you.
Just so you're aware of that.
Explain why or not?
Well, for the reasons argued in the motion to strike, because it just did not seem appropriate or fair to put a significant number of authorities that could have been cited in the briefs on the eve of oral argument before the court. It's almost like additional briefing. That's not the purpose of a notice of supplemental authority. So that was why we struck it. Thanks. Okay, are you ready?
Yes.
Thanks.
Good morning, Hinda Klein here on behalf of the appellants CES and Mr. Foster. Our first issue on appeal is that the trial court erred in denying our motion for involuntary dismissal. The grounds of that motion are more clearly set forth in the closing arguments, but it was always our position that CROOM failed to prove its damages were caused by CES and Foster's negligence.
Do I correctly understand your position to be, with regard to the various elements of damages, you've really made an all-or-nothing argument? You've said they haven't proved damages, they don't get anything.
Yes.
You haven't picked it into, so that you haven't made an argument where we could say, well, this piece of the damage wasn't appropriate, so we ought to get rid of that.
That's correct. At the trial, at the conclusion of the trial, when the judge asked trial counsel, what is your position on the damages, Mr. Brannigan's response was zero, because we believe that they were not proved with reasonable certainty, and opposing counsel himself admitted at the trial that they essentially chose an arbitrary start date for those damages and basically said to the court, give us everything we expended from this particular start date, but never took it any further and showed, first of all, why that start date would have been appropriate. And in fact, I think in their answer brief, they gave 6 different potential dates and basically said to the court, pick one. And then there was no explanation as to why all of the damages or any portion of the damages was a proximate result of CROOM and CES's, CES and Foster's negligence.
Did they testify that if the wells had been disclosed to them, they would have stopped the process or abandoned the project?
They did, but the undisputed evidence is that once the wells were disclosed to them some 2 months later, they didn't abandon the project. They not only didn't abandon the project, they went through more and more and more money after it, and then they also testified very clearly.
From their testimony and their evidence was that the existence was disclosed, but they were disclosed as non-problematic because they were not the kind of wells that would need to even be disclosed to DEP or that would stop the project, when that was not true. The testimony was that if they had just checked the permit, they would have found that it was a well that could have been used for drinking water, potable water well, and that if they had just done the inspection that they should have done, they would have found that the other well wasn't abandoned. So I don't understand how the fact that the well was disclosed as a non-issue would put them on notice of anything.
Well, and I keep getting the Knox and McCune wells confused, but the McCune well was permitted as an irrigation well.
Which everyone conceded could be switched over to be a drinking well.
It could be, depending on the homeowner's intent. But that wouldn't have been discerned from the permit or the well search.
Is that the well that at the time already had lines run from the irrigation well to the residential trailer?
I think at the time that Mr. Foster went out and saw it, which was 2 years before...
I thought the evidence was that if they had gone to see it, they would have seen that it was connected to a residential trailer at the time.
Honestly, Judge, I'm not 100% sure on this, and I don't want to misrepresent the record, but I do recall that 2 years later, when CROOM went out to actually look at the well, it was in a different state than it had been in when Mr. Foster went to see it, and he testified that at the time he went to see it, it didn't look to be, it had no electrical to it, et
I
cetera.
sort of got you sidetracked from the damages issue, but what we were focused on was, so assuming that the testimony was if they had disclosed the problems associated with these wells when they should have, that, I mean, the defendant, I mean, the plaintiff testified that from that point, when it should have been disclosed forward, I spent $1.4 million that I would not have spent if they had told me that these wells were a potential problem and I had tried to deal with them, right? I mean, that was his testimony. And then it was backed up with all sorts of billing records and everything. There was...
It was his testimony that it became not economically feasible, but it was also his testimony that he had never actually done a feasibility study. They clearly...
Credibility doesn't go to the weight. I mean, it goes to weight, it doesn't go to whether or not it's sufficient to support the verdict.
Absolutely, I agree with that, but the fact remains that as of August of 2008, they not only knew about these wells, but knew about the potential problems, but, and I want
It's
to...
still saying they could overcome these problems.
And
Even after the adverse ruling, wasn't your client telling them they should appeal this because they can beat this?
I don't believe our client told them that. I believe that their attorneys told them that, and Mr. Hamilton testified that they believed that they had a legitimate chance of overturning the DEP's ruling on this. And it's not a black and white thing. It is not a situation where simply because there were two potentially potable wells within 500 feet, that's the end of it. There were things that could have been done to mitigate that. Even Mr. Hamilton testified, well, I could have made...
I think I've heard in the briefing, I've read some good arguments, mitigation of damages arguments, but your affirmative defense was stricken and you never repled mitigation of damages or argued that, correct?
That's correct, but I don't believe it's necessarily a mitigation of damages issue. Their position was it was all over at the time that we discovered these wells, but in fact it wasn't. There were numerous things that could have been done to get around the well prohibition. The well prohibition is only one of 10 or 20 prohibitions, all of which even their expert admitted were equally important, and any one of which could have posed and might have posed a problem along the way. And if you look in the record, you can see that there was no attempt at any time after they discovered these wells to approach these homeowners to ask them to move it, can we build you a different one?
That sounds like failure to mitigate defenses, which you haven't pled, so how can that argument be presented?
Well, I think that it was incumbent upon the plaintiff as part of their burden of proof to actually demonstrate with reasonable certainty that but for the alleged negligence, or I can't say alleged because we essentially haven't appealed that, but for the negligence, we would not have incurred these expenses. And that is not clear from this record. And in fact, the opposite is clear. They made no attempt to fix that problem, and it is abundantly clear that there were numerous ways to have fixed it.
I mean, the negligence was you didn't tell me that the issue was, that this was a problem. So it seems like an odd response to say they didn't do anything to fix the problem when the negligence was you didn't tell me this was a problem, and you didn't appeal that. I mean, why would you go about fixing something that your expert tells you is not a problem?
In August of 2008, they knew about it, they knew about the problem.
They knew about wells, but they were told they weren't a problem.
They knew that one was apparently abandoned, and they knew that the other one had been permitted as an irrigation well and not a potable well. and there was a great deal of discussion, including various lawyers, and in fact, if you look at that August email stream, you see they threw out various ways to, well, if it's a permitted irrigation well, it doesn't, according to the rules, have to necessarily be disclosed as a potable well. They were, in fact, listed in the well inventory that was before the DEP. The question was, well, if it was permitted as one thing and then became another, does that mean that it is a potable well according to the rules of the DEP and the statutes? It was essentially something that wasn't a black and white thing. It was something that could have and was argued before DOA. And even Mr. Hamilton said, listen, we pursued the DOA hearing because we really thought we had a legitimate chance of overcoming this. But at the end of the day, you also have the complicating factor about the liner. And the DOA ruling said, we are denying this in part because of the absence of a liner. And that is something that Mr. Foster and CES had no responsibility for. That was a change in statute that went into effect while these proceedings were pending. And at no point during this trial did they say, well, you didn't tell us about that, or blame it on Foster. So if at the end of the day it would have been denied regardless.
Testimony that if it had just been the liner problem, they would have gone ahead and put in the liner?
The testimony on that was kind of unclear. There was testimony from Mr. Wesley that somehow they were interrelated with the well issue, but then he never really explained that. And actually,
He did explain that. He said that the liner didn't become an issue except for the wells. The DEP always in their discussions said, you have these wells here, we need a liner. And second, he said that because of the wells, you'd have to half the size of the project, and if you did that, it would make putting the liner in unfeasible. If the wells were not there, then I could have lined the whole thing and it'd been fine. I mean, I thought that was his testimony.
Except that they never introduced any evidence as to the cost of the liner, and they never made any attempt before
But that was his
DOA.
testimony, basically, right?
Why would they make an attempt to put in the liner if they know there's this other thing that's going to keep them from getting approved?
Well, their position was that the liner was interrelated with the wells, but if you look at the revised statute that went into effect, I think it was in 2010, it shifted the burden of proof to them before DOA to demonstrate that a liner wasn't needed, and the statute says absolutely nothing about potable wells in the area.
From a causation standpoint, if you look at the timing, they didn't disclose the wells, and DEP was ready to issue the permit and would have done it before this requirement ever came into effect. The permit would have been issued, but when the well issue was brought to their attention by those homeowners, that delayed everything and got it to the point where a liner was required. Why isn't that part of the causation analysis? If you had... Well, it would have been permitted without a liner if the well issue hadn't...
But the ultimate issue was whether or not they were damaged as a result of their reliance on Foster. And there was no reason that, because they were disclosed to the DEP in the well inventory, and there was an argument to be made as to why neither of them had to be included in the well map that was also before the DEP. They were all a party to this. They made a calculated decision. We have a good argument for not disclosing this, and let's go ahead and see if these homeowners actually make that 15-day deadline for filing an objection. It was a calculated risk. It was one that they were clearly aware of, and that at all times after August of 2008, not only did CROOM know about it, but their lawyers knew everything there was to know about it. The lawyers were on notice that there was a potential potential problem as to whether or not either of these two wells could be deemed to be potable and required to have been disclosed. But it wasn't the failure to disclose that was the reason why the DEP issued a notice of intent to deny. And even more important than that, DOA gave them, I think it was 3 or 6 months of an abatement in order to work this out with the homeowners. And in fact, at one point, they had indicated to DOA that we do have a potential settlement with these homeowners. So it was far from a foregone conclusion that simply as a result of Mr. Foster's failure to have disclosed this in June versus August, that this whole project was futile at that point. Far from it. In any event, our second point on appeal was that, given the complexity of this case, it really was difficult to discern from the trial court's final judgment how it was that the trial court made the determination that in May of 2008, the damages in question should start to accrue. As the court's aware, we did ask the court to clarify that, and to some extent, the court clarified it just simply by listing the various evidence regarding negligence, but never actually clarified why it was that the damages would accrue on X date versus Y date, and that is problematic, especially since opposing counsel's argument was, well, it could have been June, it could have been September, excuse me, September, and the trial court's only response, other than clarifying the negligence issues to the post-trial motion was, well, I don't have to do that. And we would submit that if the trial court had made findings of fact, it would enable this court to more clearly review the case to see if, in fact, there are grounds for reversal. Finally, I just wanted to bring up the issue of the trial court's error in striking the potential expert that we might have had, which might have...
Did you ever proffer an expert or testimony? Do we have any way of knowing whether you would have been even able to find an expert to testify contrary to what the other expert said?
No, we did not. We did not.
Then how do we know there's any harmful error by what the trial judge did?
Well, this is a malpractice case, and it's one that is highly technical. And even opposing counsel emphasized in his closing argument, I think it's on page 590 of the trial transcript, look, the only expert you heard was Mr. Wesley, so you have to buy everything he said.
We have no reason to know that the court would have heard any other expert if the court had ruled differently.
That's absolutely correct.
So it doesn't change anything, does it?
No, but I believe that under the circumstances, Judge, that I think the error was palpable here and obvious.
In terms of a preserved error, when the judge was considering the motion to strike, as I read the hearing, counsel below said, well, basically, I don't need an expert. My client can testify, and when the jury hears my client, they're not going to, they're going to know that it's going to be clear and obvious that there was no negligence on my client's part. And then the trial judge gave a time to demonstrate excusable neglect and waited until after that time, and there was nothing submitted in furtherance of the argument that, an expert shouldn't be stricken, and the judge just went ahead and entered the order. So, I mean, I'm having a hard time understanding.
Well, first of all, the excusable neglect, I was kind of confused about that because the neglect was we don't have an expert to disclose yet.
Well,
so it really
was they didn't file a response timely to the interrogatories in which
Yes.
they said under oath, we don't have an expert yet.
That's correct. They advised opposing counsel orally.
I mean, that takes 5 minutes, right? Why wasn't that done?
And the trial lawyer said, I don't have an excuse for that. And if, and I certainly can't argue that, to the extent that they had to make this motion that they weren't prejudiced. But Judge, I think that striking an expert even before the trial was set.
Make the argument that you can't strike our expert, it's too harsh a sanction. Here are
Yes.
the cases that say that.
He did not cite case law. He did make the argument on several occasions, really, this is too harmful, and with respect to the issue about whether or not an expert was needed, it was the judge, and only the judge, who said, you know, he's an expert, he can testify in his own behalf, but in a malpractice case, that's not something that's really going to be of assistance, because clearly, and in fact, he testified during the trial that he wasn't a landfill expert, and therefore, just given the nature of the case, we submit that we did need expert testimony, that it really would have clarified a great number of things, and we believe that in the event the court doesn't reverse for judgment in our favor, it should reverse for a new trial on that. Thank you.
Thank you.
Your Honor, Dave Banker for CROOM Investments, and with me is Mr. Hamilton, who is one of the owners of CROOM. I think it might be helpful, and I very much appreciate that y'all have taken the time to digest the innumerable facts in this dispute, because I know the facts are pretty dense, but I think it might be helpful for y'all to understand two basics. There are two wells that turned out to be infringing wells. One was what we call the McCune well. The McCune well had been permitted as an irrigation well. So SwiftMud is the permitting authority. On the permit it says irrigation well. That well wasn't disclosed in the well search that the defendant did way back in May, when they were supposed to clear the potable well setback prohibition. Judge Lawson, you are exactly correct. In evidence...
Don't use those words with him.
No, it's fine.
You were lucky. No, in evidence, what McCune had done, and I forget whether it was McCune or his son-in-law Lawson, I get them confused, McCune or Fannin, but he had a trailer, which was a mobile home trailer, and he had connected pipes from the well, the irrigation well, to his mobile home. Now, what we figured out, what the client figured out afterwards, that makes it potable, because it's the intended use of the well. So that well was potable by the mid-summer of 2008, and that was a fact. That was a fact. That was no dispute. That was something that was knowable by the person who was supposed to do the well search and clear the well prohibition. So our expert said that that was negligence, not to do the due diligence, match the well with the permit, figure out how it's being used, and determine whether it's potable. That was clearly negligence. We would have stopped right there based on McCune, because what Mr. Hamilton explained is that the capacity of the landfill was everything. The only way you can make money on a landfill is by having capacity to put stuff in. Capacity was so important that CROOM had diligently preserved the capacity of the landfill by buying what it thought was the only potable well that it didn't control, which was the Wright property to the south. And that was a well, and there's a dispute in the testimony, and frankly, the other side has misstated the facts. The defendants identified the Wright well as, they said, there's a house on that property, they're going to have a potable well, there's no water and sewer out here, you're going to have to control that well. We tried to persuade the owner to move the well. The owner said, okay, you can drill me another well. You know, you pay for it, that's fine. Owner changed his mind, stuck us up, and said, you're going to have to buy my property at a premium if you want my well. So, I mean, there's no doubt we are relying on the full capacity of this landfill. We paid $250,000 for the Wright property to preserve the capacity. What happened was, because the McCune well was there, that eliminated the very capacity that we spent $250,000 to acquire. We thought we had preserved that, but if you do the concentric circles around the different properties, and this is all in evidence, that eliminated the capacity. More troubling more troubling than the McCune well. The McCune well, you could say, well, the defendant could have been confused by the permit, because the permit said irrigation well. It still doesn't explain why he didn't even find that the well existed. The evidence said, or the standard of care required him to go out and find the well. He didn't even do that. The other well is totally inexplicable. The Knox well was pretty close. Knox had the property next to the McCune property. That well had always been permitted as a potable well from day one, and the permit was in evidence. It would have been permitted way back in 1995 as a permitted potable well. They didn't discover that well either. When they do discover them in August, it's garbage in, garbage out. They tell us that the Knox well is unpermitted. Well, it's permitted, but they told us it's not permitted. And they tell us it's an abandoned well, probably an abandoned irrigation well. It doesn't count. Don't worry about it. And on McCune, they tell us that it's an irrigation well, and I don't want to use bad language, but the internal communications, irrigation wells don't mean SH blank T with regard to landfills. It's only potable wells. So, and the testimony is clear. Why didn't we negotiate with the owners? We had no reason to, because we were told in undisputed conversations, which Mr. Foster didn't deny, but he couldn't remember, that the wells didn't count. They didn't matter. They didn't even have to be disclosed in Mr. Foster's hydrogeology report. And this is the dodge to say that the well inventory discloses the well. The well inventory is a printout that you or I or anybody else can go to SwiftMud, and they'll print it out for a region, and it'll list, 3,000 wells that are in that region. That doesn't tell you anything, which is why what FDEP wants is the well map. And they want the certified professional, in this case the geologist, to prepare the certified well map that takes all of those wells on that inventory and locates the wells that are within 500 feet of the perimeter of the landfill. And you've got to show on there the wells that are potable, that are within 500 feet. And so to say there's an inventory is meaningless. But on the well map, our guy, who we're paying good money to, says, you don't need to worry about these wells. They're not potable. They don't count. I don't even need to put them on my well map. I don't even need to tell the permitting authority about them. So we go, we spend a ton of money pursuing a permit that was never permittable. It was never permittable. Who would do that? Who would spend $1.5 million pursuing something that the permitting authority absolutely must deny because it is a prohibition? Prohibition will not be issued. And that was the undisputed evidence in the case. That's what the statute says, it's a prohibition. That's what our experts said. They want to say that, that their negligence, their clear admitted negligence, repeated negligence, which began in May and continued throughout the permitting process, even in his deposition in this case, which was pending while the administrative challenge was being pursued, Mr. Foster, didn't understand the well regulations and maintained under oath in his deposition that these were not potable wells, that they didn't count, and that they shouldn't have been on the well map. So they want to say that we have to prove that the permit would have been issued and that the only reason for denial was the reason of their negligence, which was their messing up the well search and messing up the information that they gave us and messing up telling us that these were not potable when in fact they were and that they didn't count. And the answer to that is no. What we had to prove, we didn't have to prove that their negligence was the only reason for the permit denial. We had to prove that their negligence was a reason for the permit denial, and that we relied on it, because who would pursue something that will definitely be denied for a prohibition? So it's not a profits case. We didn't, in the supplemental authorities that I submitted, a lot of them dealt with, I wasn't familiar with it, you guys probably are, but the flexibility rule of damages. And the flexibility rule of damages says that you can prove lost profits.
I'm here if it's in your supplemental authority, because...
The one that we struck?
The one, or is it in...
Well, but it's in the cases that were cited too, in the Minotti case that she cited in her reply brief. And, I mean, I wasn't trying to ambush anybody, I was just getting ready for this, before the argument, and dug all this stuff up. But Minotti says, and there are a bunch of other cases that are cited, that, that Florida uses the flexibility rule, and you can pursue reliance damages or you can pursue profits, and the judge should award the one which more fully compensates. And it's only if you prove profits that you have to prove certainty. You don't prove that you incurred damages and expenses in reliance on someone's negligence with certainty. That just doesn't make sense. You just prove that you incurred them. And we explained all of our damages.
Well, in a negligence claim, though, causation is an element.
Sure it is.
Right. So, I mean, I think their argument is that even if you proved that you relied on the well stuff, that if the permit was ultimately denied for two reasons, one being something you didn't address, that you have a causation problem there.
But our evidence was that we would have stopped immediately and done something differently if we had been told that this violates a prohibition. Because a prohibition, the permitting authority has no discretion to grant the permit. It's dead in the water. There's a list of prohibitions. So, why would you pursue it, if it's going to be denied? So we're saying we should have been told. We were deprived of the opportunity to try to deal with this, like we did with the Wright property, where we bought the Wright property when he told us that it had a potable well, and we preserved the capacity of the landfill. So, and I would say that the reasons, if you read, this permit was going to be granted based on their certification. This permit was granted. They know the FDEP issued the intent to issue the permit, assuming no potable wells, without a liner. It was going to be issued unlined. That proves causation right there. It's only after the well challenge by McCune, based on the McCune and Knox wells, that FDEP re-examines it. They determines, hey, you've got potable wells here that violate the setback. And then they deny it for two reasons. They say, we're denying it because of the potable wells, and we're going to require a liner. And if you read the denial when they require the liner, they say that those two reasons are related. They say because the water flow is two adjacent wells, including the two within the setback, McCune and Knox, we're going to require a liner. So the reasons are very much related. Very much related. But they don't even have to be under our theory. We have to show simply that their negligence caused us to proceed to pursue a permit that would necessarily be denied because of the violation of a prohibition. I hope I'm making that clear. Under the jury instructions, undoubtedly it's a substantial contributing factor, their negligence. Even if you say that there was another cause of the permit denial, undoubtedly the potable well setback was a substantial contributing factor. The concurring cause instruction fits. They cited the Proto case in their reply brief, which talks about substantial contributing cause, concurring cause, and says that in order to be regarded as cause of damage, it doesn't have to be the only cause. Negligence can operate in combination with some other cause. There's some good cases, and these are in the what was stricken, and I'm sorry I didn't find them before, but they might be worth looking at. And I was just trying to give you guys what...
I mean, we've made it clear that we don't want you arguing things in something that we've stricken.
But there's almost a presumptive causation in this types of case, where material information is withheld by a professional on a course of action. Causation is presumed under the law, under these circumstances. They complain about the feasibility. That goes to the weight of the evidence as well, but there's another point. our damages were all recoverable because the only evidence in the case was that this whole process was a waste of time. We were going to have to start all over again at the beginning, square one. We were going to have to get new plans, new closure documents, new bonding, new well monitoring system. We had to get a whole new permit if we were going to do assuming that a landfill half the size would have worked. We were going to have to get a whole new permit and go back to square one all over again. So it's a reliance case. Everything was wasted when it didn't have to be, if we had been properly advised. We were repeatedly assured throughout the permitting process, this is in the testimony, pages 123, 125, 202, 204, 211, 213, and 214 of Hamilton's testimony, that he was reassured at all times by Mr. Foster that the permit complied. We had to close the 2 potable wells that we knew about. We had to submit affidavits to assure FDEP that those would be shut down in the proper way and not be potable because they were within the landfill footprint. Mr. Hamilton testified that he thought that took care of any potable well problem when we submitted the affidavits in the supplemental submissions requested by FDEP when they wanted more information about the permit. So we're constantly being reassured all along the way that we've done what we need to do to comply with the prohibitions, when in fact it was knowable and should have been known and should have been reported to us that we violated the potable well prohibition before we even began. The administrative challenge, the testimony on that was that was our best and only option. That's page 508 to 510 and page 522, that CROOM determined that its best option was to try to salvage through the administrative challenge because they really had no other option. A half-size landfill, they would have had to start all over, start the whole permitting process. It was a latch-stitch effort. And when you've invested, the testimony was, when you've invested $1.5 million in something, throwing $20,000 more to try and salvage the effort through the administrative process was worth the effort. And there was no contrary evidence. There was no contrary evidence that we had some other option that we should have pursued. Nobody tried to show that there was a better option other than what we did. They left us in the ditch. So we had to try and figure it out, and we did the best we could. And the judge accepted that, which was his prerogative. We did not have to prove our damages with reasonable certainty. That is a standard for future damages. It's a standard for lost profits. It's not a standard for reliance, damages, past expenses, which is what we claimed. As far as findings of fact, the judge's judgment and his clarification of the judgment are very, very clear. He says that the negligence began in May with the negligent well search, which inexplicably failed to reveal the Knox and McCune wells. It continued throughout the process with the certifications in June that all prohibitions were complied with. It continued in July with the draft hydrogeology report that they sent to us, which said that the potable well setback prohibition had been cleared. It continued in August when they assured us that McCune and Knox, which had belatedly surfaced, did not count and did not need to be included in the well map. It continued with each of the four very costly supplemental submissions which FDEP requested during the permitting process, where they wanted more information about everything, when we were assured at all times that our permit complied with the prohibitions. There were no objections to anything. There were no objections to any of our damages. Everything was admitted by stipulation. Nobody challenged any of the damages as unreasonable, as not necessary, as not related, as not caused by the negligence. we did far more than we needed to do in proving up our damages. We had an elaborate schedule which itemized everything out. It broke it down by dates. It showed the dates on which the damages began. It showed the dates on which they ended. It extracted out the damages. They represented to you that we claimed damages before the engagement of the defendant. That's not true. I know it was an honest mistake, but it's not true. We carefully scheduled out all our damages. We had our witnesses explain exactly what each component of damages were. It was very, very clear, and we set it out in a manner that the judge could start it at different dates. He could have started it on March 22 with the engagement of the defendants. He could have started it on May 20 with the negligent well search. He could have started it on July 1 with the draft hydrogeology report. He could have started it in August with the negligent reporting of the belatedly discovered wells. He could have started it on September 8 with the submission of the application, with the misrepresentations to FDEP that everything had been complied with. He could have started it at any time during the permitting process.
Okay, thank you very much.
I'm sorry, I get worked up.
I'll be very brief, and I just wanted to point out to the court certain portions of the record relevant to some of the issues that were raised by opposing counsel. I do want to emphasize that there was no deadline ever given to Mr. Foster to perform his well search, and Mr. Hamilton acknowledged that during his testimony. And Mr. Hamilton also testified at the record 18 pages 521 and 522 that had he known about these wells, he would have purchased them, but then also conceded that he never attempted to purchase them after he found out about the wells. He also testified that he had never done an economic analysis as to the difference between the landfill as originally designed and the landfill that could have been done to get around the McCune and Knox wells, and that's at the record 14 pages 165 to 167 and 18 521 to 522. I also wanted to bring up to the court that the Wright well, which was purchased for $250,000, was bought by Mr. Hamilton even before that Mr. Amin had asked Mr. Foster to perform that well search. There is no deadline at any place in Mr. Foster's contract, and he was never advised that time was of the essence. And finally, I did want to point out to the court that in that August 2008 string of emails, Mr. Foster actually suggested to Mr. Hamilton and the numerous other people on that email chain, including two attorneys, that they should move they should ask the McCune and Knox people if they could move those wells or buy the property or take some other action. So to now say that everything was done in reliance on Foster saying not to worry about it ignores the fact that the record clearly shows that he suggested it was something to worry about.
Your time's expired, and see if there are any questions. Any questions? Okay, very well argued case. Thank you.
Thank you.
Both very much. Appreciate it. Court's in recess.